I've been asked to let you know that some of our sponsors, representatives, are out there giving away free books. I think Aspen is there, and did she say anyone else? No. So they would love us to go out there and take free things. So we're here to talk about introducing simulations in the writing curriculum. And most writing programs have moot court, and that has traditionally been the only sort of simulation that students have had. And as we know, moot court, appellate advocacy is something that not that many lawyers actually do. I know that some schools, instead of doing an appellate program, do have a trial-based moot court, but again, if you're sticking with the appellate model, it's something that's fun, and it does teach a lot of skills, but it's not something that most students will do. So over the years, we've tried to introduce some simulations that more closely approximate what these students might do when they graduate and if they get a job. So we're going to talk about two things today. We're going to talk first of all about Jennifer Taylor is my associate director, and she's going to talk about a simulation we've introduced into the first year writing program. And then I'm going to talk about a class I teach, an upper class writing class that's called an advanced legal writing and editing workshop that I've been co-teaching with the clinical faculty for years, and how we introduce simulations in that. And we're not going to talk for the whole time, so we want to hear what other people's ideas, thoughts, questions are. And I will hand out the syllabus of the upper class before I speak, but right now I'm going to turn things over to my associate director, Jennifer Taylor.
Okay, so as Professor Volk said, my name is Jennifer Taylor. I'm the associate director of the legal writing and appellate advocacy programs at BU. And I am going to talk about the simulation we introduced to the 1L class 2 years ago. We changed our syllabus a little bit and found ourselves with an extra week, and normally it would have been sort of a week off for the students. They had just turned in a draft. The instructors would be grading them. We'd sort of give them a week off. But we decided instead of giving them a week off, we would have another class. And in that class, we would do sort of a fun class. And I, in particular, am interested, as Professor Volk said, we're going to leave room for people to talk and ask questions. Because we've just started doing this with the 1Ls, I'd love to hear about things other people are doing with 1Ls, any suggestions people might have, because this is definitely evolving as we've been doing it. So we make this sort of client interview simulation part of the first year's first real memo. It's a closed memo assignment. It's a bankruptcy issue, specifically a law student who has not been able to find a job. Professor Volk writes the assignment. It's terrible. Tell them the name
of the law student.
Alec Rodriguez, like the baseball player. So this law student who's been sort of unable to find a job wants to discharge his student loans in bankruptcy. We give them a fact pattern. We give them 3 cases, and they write a draft of an office memo. When they turn in that draft, we meet again for class, and they are given a chance to interview their client. We have the writing fellows act as clients. Professor Volk actually gives them additional confidential facts. And the point of the interview for these students is to, now that they've done the draft of the memo, ask questions about maybe facts they would like to know more about, something that wasn't explained that fully in the fact pattern. Now that they've read the cases, is there anything they can see from the cases that might be relevant that they didn't get in the fact pattern? So the example I always try to lead them towards is, I think all 3 cases talk about having dependents and how having dependents is a factor in whether you can discharge your loans. The facts we give them don't say anything about whether Alec, or if your writing fellow is a woman, Alexa, Rodriguez has dependents. So that's one of the confidential facts we give them that they can try to get out from their client. Because they are first years, we don't ask them to then incorporate those new facts into their next draft. We ask them to stick to the original fact pattern that they were given, because they're still just learning to write memos. I mean, it really is their first memo assignment. So I'm going to walk through sort of what I do with them in class. over the course of this interview. So I start by talking a little bit with them about why they might be doing a client interview, and I let them know that when I worked at a law firm, that was actually one of the things I got to do even as a junior associate, maybe not a big, super important client, but we did a lot of custodian interviews when we were doing discovery intake. I did a fair number of client interviews if we were representing, say, third-party witnesses in a government investigation, something like that. And so it is something that they might get an opportunity to do or participate in pretty early on in their careers. So we want them to know that it is important. I let them know that the purpose, of course, is to gather facts, but it's also to learn your client's story, right? Why are they there? What do they want? What are their motivations? What do they care about? And they're not always forthcoming with that. Sometimes you have to just listen to them and let them go through their story, and not focus too much right away on just getting those facts out, because you might miss something. So to that end, I start by explaining that they want to set an appropriate tone, right? Someone comes in, if they're upset, if it's a personal issue in particular, things like a divorce case, they might be very upset. You want to be sympathetic and empathetic, but still professional. You have to set that sort of appropriate tone with them. And throughout, you have to maintain that tone. With the bankruptcy issue, my students at least tend to get a little bit judgmental of their client. Well, why did you do that? It's like, okay, you can't be judgmental. You have to be respectful of your client's choices. You have to be neutral. And so one of the things to that end is, as they start off by introducing themselves to their client, asking why their client is there, if they don't sort of set the appropriate tone right away, I stop them. We talk about, okay, you jumped too quickly right into a detailed factual question. You need to step back. Some years I have a student who does a great job setting the tone, and then I can stop and say, this is an example of exactly what you would want to do. So it works nicely because it works either way. Whenever a student asks a particularly good question or phrases something particularly well, I can stop and highlight that as a good example. Conversely, if they do something that maybe they shouldn't be doing in a client interview, I can stop them and say, okay, what was imperfect about that question, and they can give each other feedback because they're all doing this as a group. And one of them might have an idea about maybe why that wasn't the best question to ask or the right tone to use. We also focus on having them ask open-ended questions, of course. And that's certainly something they struggle with, especially because for this simulation, they've already written a memo. They have very specific factual questions that they want to ask. And so I frequently stop them throughout the simulation if they're asking a question that is, too yes or no. And then we, again, talk as a class. What would be a more open-ended way to ask that particular question? What's the information you're trying to get there? Can we think of a different way to get at that information that might open your client up a little bit more and get you more? And I can do the same thing with follow-up questions. So we talk about, you want to have certainly a rough outline when you're doing a client interview of what you want to get through and the information you're trying to get, especially if it is, a follow-up interview where you've already gotten some facts and done some research. But at the same time, you want to make sure you kind of thoroughly explore and let your client thoroughly discuss a particular topic before rushing them on to the next. And that can be a really big challenge with, 12, 13 people trying to interview a client all at once. They all have they're very excited, they all have different things they want to ask about. They start cutting people off, they start rushing to another factual issue that they want to get to. So again, we'll stop and say, okay, is there anything else you might want to know about, fact scenario A before you move on to this next thing? And we take a step back, and they can work with each other in that way as well. Finally, we stress the importance, of course, of the rules of professional conduct. So after they've had a chance to interview their client for about half an hour, I stop them and I ask them to give their client some advice. again, since they've written a draft and because we designed the assignment a certain way, some of them come out thinking this person will be able to discharge their loans. Most of them, because it's wishful thinking. A few, though, recognize that it is very difficult to discharge your student loans. So I asked a few students who came out on the yes, you will be able to discharge side to advise their client and to explain why, in lay terms, even though their client technically has a JD, why they think that the bankruptcy court would allow them to discharge their loans. And then I asked some of the students who came out the other way in their draft to explain to their client why they think the court will not discharge their loans. And again, I try to get them to give each other feedback on their explanations. Was it, pretend your client doesn't have a JD and explain to them, these three factors in lay terms, and work with each other to do that. We spend a few minutes talking about, model rule professional conduct 2.1, that you have to render candid and honest advice. Obviously, sometimes clients come in and they're upset or they want a particular answer. They want, if they want to sue someone or they want their suit or their bankruptcy request to be successful, they're not going to like it if you have to tell them that you don't think they will be successful. And how do you deal with that? How do you handle a client who's obviously upset or obviously wants a particular answer if you don't feel like you can give them that answer in your honest opinion? And so we spend a little bit of time just reinforcing, even though they're just 1Ls, that you really do need to be honest. It's really important. And then finally, even though we are not asking them to incorporate these new facts into their drafts, I do like to talk with them a little bit about whether they learned anything that they think would change their analysis if they were allowed to use those facts, because I think it's a useful analytical exercise for them to do. So when we first started that assignment, actually, when we first introduced the client counseling assignment, the first year I did it, I wasn't sure how it was going to go, or if I would have enough to sort of get through a whole class. And I'm consistently amazed. I mean, they are full of questions, and sort of walking them through each of these things that they can learn just from this one exercise. I now wish it were a longer class, actually. We do a 50-minute class. And I think that's all I have to say about mine.
I just want to talk about it from my standpoint, because I'm the director of the program, and we have an adjunct program. So we have 21 adjunct instructors in the first year, and my concern was, how are these guys going to do it? I mean, they're adjuncts, some of them do this for work, some of them don't. And I observe all the new teachers' classes. So I've seen quite a few of these classes where the students do it. And I have to say, teachers approach it differently, but it all seems to work very well. The students, some of them are shy to begin with. It's a little awkward to start. But I've found that in all the classes I've observed that teach this, it's probably like 5 or 6 by now, it's very popular. The students seem to like it. The instructors like it. And they take different approaches. Some classes take it more as a counseling approach, like what are you going to tell this guy about whether he or she can discharge their loans? And as a byproduct of that, what else you want to know, because we do give them additional facts. And it is interesting because most of the students do conclude that he can discharge his loans, which is not true, but it's plausible, but it's really not true.
Plausible within the structure of the edited cases we've given them.
Well, I have one bankruptcy lawyer who's an adjunct, and she said, no way. But anyway, they're happy to live in a fantasy world for a little bit. But, one thing that was good about this is because we have so many instructors, it gives the instructors a lot of freedom on how they want to structure the class and how they want to work in this. And the writing fellows themselves really enjoy doing it. Our writing fellows are upper class law students, mostly all second years, who I've selected through an interview and application process. Last year we had 60 applicants. I interviewed 60 students, but basically it's based on the recommendations of their instructor and their prior writing fellow. So they get very into it as well, playing the part and doing it. So it's been very successful, and it's turned out to be a good use of this extra class.
Yeah, it's now one of my favorite classes, I would say, to teach.
Good.
I really like it.
So we're going to move now to the upper class. I brought a copy of my syllabus for everybody. I mean, it's not groundbreaking, but I think it's, you want it? You've got it. How about that? One thing I learned as a teacher is always divide the handouts in half, because they get passed out faster. It's a good learning experience. So, I've been teaching this advanced writing class with a clinical instructor who was originally a writing instructor. Did you know that?
I didn't.
Yeah. In fact, she became a writing instructor the first year I was director, and then I think after about 7 or 8 years of that, she moved to our clinic. And we also teach together in our London program in the summer. So this class is designed to help students improve their writing skills in terms of producing quality legal documents, but also just out-and-out writing. It's style and organization as well as document preparation. And in this class, students work on 3 different documents: an office memo, a client letter, and then a motion and memo in support thereof. And what we do that I think is a little different in this class is we do not give them the facts at all. We don't give them the written facts. We have people come in and play the 2 principal parties in the case. And it's generally, I've been lucky enough to find non-lawyers. This year I used 2 non-lawyers. I had a woman who worked as an assistant registrar in the law school, and another woman who worked in the payroll office. And so they're really not lawyers. And the case involves, I picked crazy fact patterns.
I love this case. I got to be the client one time.
Yeah. We were desperate that year. So this case involves a kid, a 7-year-old kid, who wanders into a neighbor's yard where she keeps horses. And he goes into the corral with his dog, his barky dog, and the dog barks, and the horse kicks the kid in the head and kills him. And it's an attractive nuisance issue, and it's in the great state of Wyoming. So we have, for the students to get their facts, what we do is we have one person play the horse owner and one person play the bereaved mother. And they get pretty hammy sometimes. The mom gets really hammy. So the way we work it is it's a limited enrollment class. I think it's limited to 14 or 16. And we divide the class in half. Half of them represent the mom, and half of them represent, well, the parents, and half of them represent the horse owner, landowner. And half of them work with me for half the semester, and half of them work with the other instructor, and we switch in the middle. And the other instructor is a clinical instructor with a great deal of practice experience. She works in our civil clinic, so she's very helpful to have in this class, because I haven't practiced law since before Jennifer was born, I think. Yeah, more or less.
And I'm older than I look.
And she's way older than she looks. So what we do is, in the second class, and we always make sure you have to come to the second class. If you don't come to the second class, you can't take this course. We bring in each person separately, and those students who are assigned to represent that person ask questions. And they have no idea what this case is about, nothing. So the person comes in and, they have to start. Before they come in, we try to give them some instruction on how to ask questions, how to get at facts. Open-ended question, letting the client tell the story in their own way, funneling the facts, funneling the question to get to a particular fact, and making sure that you leave the client with some idea of what's going to happen, what's going on. So it's an interesting experience. The client comes in. I always say, welcome, it's Mrs. Twist. Mm-hmm. Nice to see you today. And then I leave it up to the students. And it's very interesting to see what happens really fast. What happens really fast, and these are mostly second and third year students. Does anyone guess what happens really fast? They start cross-examining them immediately. They start like they're hostile witnesses. And this is with a woman whose kid was just kicked in the head and is dead. And they're incredibly unsympathetic and completely, is it true that, they're just getting, it's like...
Why wasn't he in school?
Why wasn't he in school that day?
What time of day was it?
What time of day is it? Why wasn't he in school? Where were you? It's just, he wasn't in school because it's the summer, and it's just amazing. And we stop them from time to time and say, whoa. Of course I say whoa because it's a horse. But, what are you doing here? What happened to this woman? What just happened to this woman? And, a lot of these kids are going to go work in the legal aid clinic, or they're going to represent people, and they're going to come in, and this poor person's going to come in and say, my son just died, or I want a divorce. And they're going to say, why are you getting a divorce? It's a very interesting experience to watch them and to see how little common sense they bring into this. These were students who are smart. I mean, our students are really smart. They don't have that much life experience, but I feel that when law students start law school, they take all their common sense and leave it outside the building. You would never talk to anybody this way. So a lot of it is just getting them to slow down, be nice, calm down, and let the client tell her story. Even though we say to the students beforehand, a good way to start an interview is to say, so tell me, what brings you here today? After that one question, they think they know what it's all about. So these interviews can take a while because they don't always get the good facts. At the end of, after the first person leaves, usually it varies who goes first. Then we have the other party, the landowner, saying, again, even though they've just watched an interview of this poor client, they start in on the landowner like they didn't hear a word we said. And think about it, the landowner, she's not that happy either, right? It's her lovely horse who kicked and their neighbors kicked the kid in the head and killed him. And she's worried, and they're like bombing right in there. It's very interesting. And they don't always get all the facts. Like, I remember one year, we're going through this, and I said, so where do these guys, after they leave, I say, so where do they live? Oh, I don't know. Yeah. Does she have any other kids? I don't know. What's she do for a living? I don't know. It's a good experience for them. And, Connie, my co-teacher, is very good because she does have the work experience, and she works in the legal aid clinic, of getting the students to think about open-ended questions that will let the clients tell their own story. So we do make sure afterwards, if there's any crucial facts they didn't get out from the client, like what state are we in, we let them know that. So then they draft. The way this class works is they draft the first draft of the office memo. We have them exchange papers with somebody on their side of the case, and they do peer editing. And Connie and I also grade the first drafts of these papers, and we meet with them in individual conferences. They do a second draft of this, and we don't have peer editing over the second draft, but Connie and I, again, go over their second draft, because we find that the first draft is just all the comments are about organization and analysis and structure. It's interesting this is a very simple legal concept, the attractive nuisance doctrine. It's interesting when students are faced with a very specific, detailed fact pattern, how hard it is for them, and how hard it is for anyone to really analyze it deeply, like, does this doctrine apply? The law is crazy on this topic. It's a very good problem in the sense that it's all about artificial condition, and is a horse an artificial condition? And obviously it's not. I mean, it's a horse, right? So when they're finished with the office memo, the next document they draft is a client letter. And, we go through instructing them how to draft a client letter. We go through the rules of professional responsibility. It's and we talk about, the organization, the structure of a client letter, writing for your audience, all the things that if you do a client letter in any of your classes, you know all about that. But what's interesting that we do that I think is very interesting is we give the first drafts of the client letters to the people who played the parties in the class. And so it's interesting because you have these two people, this year there were two women, who one of them doesn't have a bachelor's degree, one of them has a college degree, but they certainly know nothing about law. So I give them the letters, and they comment on them, and then they come to class for a client counseling session. And it's really kind of fun. So, the first one comes in and I say, "It's nice to see you again, Mrs. Twist. Do you have any questions for us?" And, the students don't always agree amongst themselves on what the result would be. I'm sure you've noticed this, what usually happens, it's a lot like what happens with the first year memo, is the clients who represent the mother generally think, oh yeah, she can recover. And the kids who write for the landowner say, oh, she's not going to be liable, which is interesting. There's a little bias built in. So, sometimes so you say the mom comes in first, and she makes comments about the letters, like what she didn't understand, questions she had. Some of the letters, again, are incredibly rude in the sense that, "Dear Mrs. Twist, you asked me if you can recover for your son's death. Unfortunately, you can't. I've decided you cannot." And, nothing like, "It was nice to see you. I'm sorry about your loss," So they're like, I felt like I was being accused in this letter. We always make them write in the letter the facts. And, I got these facts. Let me know if I made any mistake. Some of them have written things like, I've gotten these facts from an interview with you. Let me know if you haven't told me anything, or something, So it's a great learning experience for them. It's also, one of the goals of writing a client letter is to get rid of legalisms and make it so that a non-lawyer can understand this. I'm sure you know that after a week in law school, they can no longer speak English. Excuse me. My example is I always say to them, no mother ever said to their child, "Don't be negligent." I said, so because they just don't even think about what are legal terms. And having these non-lawyers read the letter is very instructive. Among the 7 or 8 letters they read, they usually get a pretty good idea of what's going on, but there's always some of them, they just say, "I don't know what you meant, I'm very confused, what does this mean?" Or the landowner will ask questions like, part of the problem in this case is there's a fence around the corral, and part of the barbed wire is missing in parts. And she says, "Should I fix the fence now? What should I do now?" And it gives the students a chance to, by now they know the case pretty well, analyze it deeper as if they were facing a real client involved in this legal problem. And, what would they say to them? We also talk about before they meet the clients, how are they going to leave them? What are they going to tell them they need to do? How are they going to make sure that the client leaves there feeling like there's a plan? What do we do next, kind of thing? So usually at the end they'll say to the mom, "So do you want to pursue this matter? What are you seeking here?" Things of that nature. They should have done that in the beginning, but they don't always do that. I feel that this session is, in a way, even more valuable than the first one for a lot of reasons. First of all, they're getting actual feedback from their intended audience instead of from us. I mean, there's, we can tell them, how it's written, how it's organized, the language, but we don't really, it's even hard for us to know what a normal person would understand. And so having normal-ish people there to read the letters is eye-opening for me sometimes, but especially for the students, because they cannot recognize what is illegalism at this point. They start writing things like, Wyoming law requires that, and the kids the clients are lost. They're lost. Where's the law? Where's it written? They just don't understand how to bridge the gap between their own legal knowledge and a lay person. So it's worked really well, and I think the students really enjoy it. And even the people who play the clients, it's fun. And it's nice and it was nice to bring the staff in when I can find. I scour the building. I go to the fourth floors where most of our administrative stuff is. I just go from room to room and ask, are you free next Wednesday at 2:30? Would you like to help us out here? And usually I can find somebody. I've gotten people who, it's hard to find non-lawyers, but I think it works best with non-lawyers because they really don't understand what they're talking about. So that's what we wanted to say. I think it's surprisingly easy. I mean, we're a very resource-poor law school, right? We have the adjuncts. I have 21 of them running around. We don't have a full, Jennifer and I are our writing staff, and our secretary left after she had a baby, so we're really like crazy. But, and she didn't come back, but what are you going to do, right? So even with very little resources, we've been able to make this work. And I think it really adds something to the writing curriculum at our school. So that's what we want to say. Yeah.
I have two questions, actually. The first is, do you allow both sides, the plaintiff and defense, to see both interviews?
We do, and we ask them to look at it as if they're in a deposition.
Okay.
So yeah, we let them see both sides.
And so I teach a very similar course, and I've done it where I play the roles, and I've done it where, at the very least, the plaintiff is someone from the law school. And it just so happened that last year my assistant was a JD. This legal market produces some assistants who are JDs. And so it was a little bit, it made me feel a little bit more at ease for this issue, which is my next question, which is the fact that the clients will, tell the students really affect my problem.
Right.
Right? I mean, and I do the simulation from really beginning to end, from complaint to summary judgment motion and settlement before trial. And so what I have to worry about is, someone coming in and sort of screwing up the problem.
Yeah, sure.
Way. So how do you deal with that?
I give each of these people, the two people playing the clients, very detailed set of facts to follow. And I tell them before class, if there's a question that you don't know the answer to, look at me. Mm-hmm. And I will say no, yes, no, yes, because I don't want them to screw it up. So I'm the king of the facts in this. I developed the problem. And so I look, I make sure that they stick to the script. And if they do have a question, then they look at me and I tell them. And then I add it to the facts for the next year to make sure that it's clear. Mm-hmm. I even have made up a map of the area and I give it to them so they know exactly, where everything is. And I used a real town in Wyoming. So that it's in a real place. One of the biggest things is that, they write the motion and memo and they make up the name of a court. Wyoming District Court. I'm like, where did you get this from, So, yeah. Yeah.
Do you memorialize the interview with a recording so that students can refer back to it?
No. And the only time I record it is if for some earth-shattering reason a student can't make it to that class, which usually means a job interview. That's the one thing. What am I going to do now, right? So, no, and we thought about it, and we don't want to. Because we want them, they got to learn and take notes. And then they mess up on their first draft, right? Because they didn't take notes properly. They don't remember what happens, and they get facts wrong. But we don't want to record it for them. We want them to get it. John?
This is the second class, right? The students don't know that this is a nuisance problem. They know
They know nothing.
none of the underlying laws. So they're asking questions both to elicit what the applicable law might be to this problem, and also to fill in the legally significant facts.
Right.
So do they get a second bite at the apple to come back, once they've done some legal research, to understand the law that applies to the problem, if they clarify that certain facts are needed?
Well, no, and first of all, there's many reasons for that. First of all, one of the reasons we pick an attractive nuisance problem is that they've already studied it as one else. So I would not do this with a subject where they didn't know something about the law. And they all remember enough about attractive nuisance. You know, they know what it's about. They recognize it, and pretty fast you can see that somebody knows, okay, attractive nuisance doctrine. Because it's a very simple thing that I think all torts teachers cover. So that's important, though, Joan.
Because I do something a little bit similar, a little bit different in my first year class. We have a covenant not to compete problem.
Right.
After we use this to teach research, we use this to teach a lot of things, but after they have done some research and we've talked a little bit about the leading case in covenant not to compete law in New Jersey and blah, 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 they have a few facts, then I play the client, and of course I'm in a class of 45 students, but I'm sitting there playing the client, and I have the students, based on the research they've done thus far, ask me questions to elicit the rest of the facts of the problem. And I don't allow laptops in my class, but for this class, I ask one student to be the recorder.
Oh, interesting.
And so we don't do a voice recording of it, but we have a transcript of the interview. And then, of course, I fix it. I change things that I feel need to be changed. If I make some mistakes in answering questions, I say, no, you misheard that. This is a real fact.
After the interviews, we do review the facts with them to make sure everyone's on the same page. After the two interviews are over, I say, okay, so, to set them, what do you think the material facts are? And we go through them in detail. Still, because it's not a piece of paper in front of them, they don't get it. Even though I write it on the damn blackboard, they still don't always get, oh, I didn't know that. That kind of stuff still happens.
But my goal for this assignment is not to teach client interview or client counseling. My goal for this assignment is to help the students solidify their understanding of the analysis of the problem,
Right.
and to understand which facts are legally significant.
But you're dealing with one else, right?
I am dealing with
Right.
one else.
That makes a difference.
And then I post, once the transcript is cleaned up to my liking, I post it on the course website so it's part of the problem.
One thing that we learned from teaching this over the years is we started out using more racy areas of the law. They don't work well. The students get too hung up in what the law is. The law takes over. You've seen this in writing assignments, right? The law is too difficult, interesting. They lose the writing part of it. So we've done a golf injury. Guy gets hit in the head with a golf ball. That has to do with standard of care. We did a release provision. Does the release provision absolve the landowner from liability? But this horse one is the best. We keep thinking of changing it, but it just works really well. There's no horse case from Wyoming. There's about 8 or 10 horse cases with kids in the whole country. It works pretty well because it's limited, right? And it's not a difficult concept to grasp. Yeah.
For Jennifer, for the first year course, kind of, I guess, maybe building on the point just made before, but so if the goal is to teach more maybe the client interviewing skills and some of that, how does that work in that setting where you have the larger classes and you have multiple, however many students?
I mean, our classes are a bit smaller because we do the 21 adjuncts. So this year I only have 11 students, which is so great. But it can be up to 14 some years. And there are always a couple of students, right, who take the lead. I usually have 3 or 4. But this year I'll say I think every single person asked at least one question, and I'll sort of moderate. So obviously you ordinarily would not raise your hand in a client interview, but ask my students to at least sort of make a little motion that they want to ask a question, and I'll try to move it along from person to person. And I mean, because they are first years, we sort of are trying to touch on, I think, a series of skills. So part of it is setting, just sort of how to start a client interview, what kinds of questions to ask. But I do try, at least this year I in particular tried to do some of that, solidifying their understanding of the case aspect of it, and left a little bit more time at the end of class to talk about, again, how what they learned might, guide their thinking about the case, even if they weren't going to use those facts. And so it's certainly a little choppy, I guess, in having to stop them too when they're asking something that's not appropriate or they're getting off track, and I want to sort of guide them back.
They get off track a lot.
They do. So it's certainly not a perfect simulation of a client interview, but I'm shocked always at how well it works, even with 11, 12, 13 students.
Have you ever tried, we have much larger classes, and we teach a predominantly writing class in the fall, and then an interviewing, counseling, and negotiation course in the spring for our first years. So
Which school are you?
I'm at University of Connecticut, and so our entire second semester is what you're talking about, and it is really fun, and the students like it. They find it, we don't do as much writing in the spring as we do in the fall, but we do some problems where the students will do a client interview and then write a memorandum and then come back and counsel based on what they've learned through their research of the law, which happens after they do that initial interview. But I was just wondering if you had, and again, with 11 students, you may not have to, but for those of you that have much larger classes, I've used the fishbowl very effectively, where the client will be sitting at a table in the front of the class, and then students will come down in pairs and conduct an interview. And it can be very helpful, especially in situations where you say the students are somewhat rude and confrontational.
The one else haven't learned how to do that yet.
The students sitting in the class will perceive that much better when they're viewing someone else doing it than if they're kind of sitting in the audience and the witnesses really by themselves in the front of the class.
Yeah, I like that.
The other thing I was going to say, and this is just because I teach predominantly writing class in the fall and a predominantly simulation class in the spring, I've tried to find ways to marry them. And I had been teaching in the first year writing class a fairly straightforward engagement ring problem. The students like engagement ring problems because they're at that age where they may actually be giving and receiving engagement rings, and they are very entranced by the fact that whether you can get the ring back if the wedding doesn't take place actually depends on what state you're in.
We've used that for moot court problem.
It's a fun problem. But I used it in the fall, and I began to like the character so much that I thought, what if I actually wrote roles for them to use in the spring? So last spring, for the first time, I introduced that problem as an interviewing and counseling problem, and it was a lot of fun. I mean, talk about hamming it up, it was. But one thing we do, and again, this is a numbers issue, our students play clients.
I was just going to ask.
And sometimes that doesn't work as well as I'd like it to work, but I will say that a lot of students, and again, this is in the spring where our focus is on interviewing, counseling, and negotiation, a lot of students say that they feel they learn a lot about what it means to be a good counselor by being a client.
Sure.
They really can,
Yeah.
perceive viscerally when the lawyer is not being clear, when the lawyer is not listening, when the lawyer is not being empathetic in a way that hits home much more than if they were on the other side. So I would recommend, again, it's hard if you're only doing one. Because then only some proportion of the class gets to be client, but in the class I teach, I try to do it so that at least once in the semester, every student has been on the receiving end of lawyering. So, and I'm happy to share, I mean, not that our program,
I'd love
not
to
that
see
it's
it.
so great.
No, but I'd love to see your syllabus.
Yeah.
Oh, sure.
I would love to see that.
This is for Jennifer. You
Yeah.
mentioned, so the facts that they elicit in the interview are not
Right.
incorporated in. Do you encounter any
Resistance.
problems for the students who want to do it? Are they always popular? Well, why do we have to do this if
Yes.
we can't use? Because it sounds like a great exercise. I'm just, students being practical.
They do want to know why they can't
Yeah.
use it, especially once they learn, if they feel like they've learned something that makes a big difference. So I think the additional facts we give are, the person does not yet have any dependents, but they do have a girlfriend or boyfriend, depending on the gender of your writing fellow, and that person is going to have a kid. No, they always have a girlfriend. And
It's always a girl, because guys can't get
right,
pregnant.
that's true. So their girlfriend's going to have a baby. It's unclear. It's unclear how that relationship's going to go, but obviously there'll be some support there. They have an additional 20 grand in credit card debt, so they have additional debt. So we do add facts that would change the analysis somewhat, and they do want to know why they can't use it. I do try to explain to them that part of it is that there are 21 different instructors, and who knows if everyone's sort of getting the same facts out.
We also can say, you don't want to do any more research, do you?
Right. So I sort of tell them that it is a closed memo, and we want them to focus on in this second draft that they're going to do, we want them to focus on the writing aspects, not necessarily on the legal analysis and the way these change the case, although it is fun to talk about those in class. But yeah, they do. They do want to change
There's a question. They all want to ask that. I get questions from random 1Ls asking, and I said, no. But it seems to work anyway.
Okay.
And I do point out that in reality, they feel like it's changing the analysis, but it's not, because, as Professor Volk said, there's no way they can discharge these loans, and so
Unless they had 7 kids.
Right. They want it to change the analysis, but in reality, it's not going to change the analysis.
That's exactly the reason why
Yeah.
I moved it before the draft, because I want to allow them to incorporate facts. And, we don't have 21, I'm just dealing with my 45
Right.
students, so I'm like the czar of the class. And so I can change whatever I want to change. And it does add a little bit of reality to this memo problem when the students feel that they have actually elicited those facts.
Well, that's what I do in the advanced class, because we have a closed universe and we're in control. But also, don't forget, we do this assignment the second week of law school.
They know nothing yet.
It's the first assignment they get is an editing assignment, and then this closed memo is the second assignment they get.
It still brings home the idea, and I like that it brings home the idea that you're not always going to get everything from an initial interview, or sometimes you're going to come into a case, you're not the first person to talk to that client, and you're going to have a file memo. And that's effectively what they're getting from us, is a file memo of facts. And that's what they're doing their assignment off of. And you might come into a case that way as a junior associate, and then you get to follow up with the client after that, and you might learn more. And sort of emphasizes that they want to, from the get-go, you want to try to get as many facts as you can, because you might learn something later that changes it.
And a lot of times at large firms, somebody hauls you into their office and tells you, look, we have this problem, blah, 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 go research it. And then you research it, and then you find out, but wait, there's more, So it is very realistic in a sad way, because you don't get that much direction oftentimes at bigger firms when, there's a lot of people involved in a case, right? Anything else we can tell you,
Do you
Gary?
find the bankruptcy problem, I mean, I know it's a
Yeah.
closed, but is that, this being their second week of law school, is that,
You can
do they
speak to
handle
that.
that?
You
I gotta
created
tell
it.
you, at first I thought, am I crazy to do this? Because it's bankruptcy. But I gotta tell you, the reason it works really well, and this is why, you do have to, in the fact pattern that they get, it explains bankruptcy to the extent they need. So in other words, it says, you file for bankruptcy, it tells them your loans are discharged, but there's a special provision that says student loans are not discharged, but there's an exception for it, and here it is. So we give them the statute, only that portion of the statute, I forget the 547 something, and it has the student loan provision. So it's explained for them. So once they read the fact pattern, it tells them what happens in bankruptcy. But why it works so well is the leading case is a Second Circuit case, and it says there are 3 factors to decide whether to discharge the student loan. See, you're all smiling. You know that, right? There are 3 factors. 1, 2, 3. And then I give them 2 cases that apply those 3 factors. 1, 2, 3. So it's super easy, it's a 3-factor test.
We spend a class, when we introduce the assignment, we have a whole class where we walk them, the instructors walk them through it, and I sit there with them and I'm like, let's refer to the first paragraph of this first case you're given. I'm going to tell you there's a multi-factor test. Can anyone tell me what that test is? And we sort of walk through it.
The court says there are 3 factors you look
Yeah.
at. Why don't I remember them now? Whether the situation's going to change.
I forget them.
I forget them. But anyway, it's like crystal clear that there are 3 factors. So we do explain to them in the the fact memo, when you file for bankruptcy, blah, blah, blah. So it leads them right to that. And it works. I mean, at first they're like, bankruptcy, but, and I tell you, that one writing instructor who's a bankruptcy attorney loves it. But yeah, it works fine. And it's mean. I like being mean. 3rd week of law school. Sorry, kids. If it doesn't work out, you can't get rid of these loans, Yeah.
I was just going to say, I actually try in both legal writing and interviewing, counseling, and negotiation to give them problems in subject areas that they have not covered in their first-year curriculum, just to let them know that when you're out in practice, you're going to be thrown things all over the board, and you have to feel confident to be able to do the research necessary. I mean, not maybe in their second week, but that they have the skills, their research skills, to really get into at least a preliminary understanding of any area of law. So I think it's good to choose.
It's really a
bankruptcy. It
statutory
takes
construction
the
problem.
fear out of it.
Yeah.
Yeah, it's just statutory construction. It's not, it's in a bankruptcy context, but it's really just applying a statute.
Yeah, even in the assignments I develop, I'm kind of mean. I make them do a confrontation clause problem, which, they do constitutional law, but they don't have a confrontation clause. And then I have them do a recreational use statute. And yeah, it's just statutory interpretation.
But for the intensive writing class, an upper class, I use something really simple.
But you want the focus on writing. They're
Right,
not,
Right.
they should know how to do research by then.
They should. Any other questions? Well, thanks for coming.
Good timing.
Hope you got some ideas. Perfect timing.
We got ideas.
We got ideas. I don't care if you did. But send me. I'm gonna give you